to the age of 16. I do have Justice for Virginia, Ashley Shapiro, who's here with me as well, who can testify. They helped me work on this bill. And so they were the ones that actually flagged it before me and said, hey, we really like the other bills, but your bill goes a little bit further. So if Ashley would like to come up just to speak to this, she can help out with answering any questions as well. But I just want to put that out there, that we want to make sure we're fighting for criminal justice reform and in the school to prison pipeline, and making sure we're going a little bit further and making sure we have this criminal justice reform. So, Ashley.
Ms. Shapiro, please, come on up.
Thank you for this opportunity, Mr. Chairman, Board, good evening. So my name is Ashley Shapiro. I am a board member for Justice for Virginia, which is a criminal justice reform group, and we've been working on criminal justice reform here in the Commonwealth. I specifically am a public defender here in the city of Richmond. I've also been a public defender up in Fairfax, and been in our system for about 8 years now. So I have extensive experience with criminal justice specifically and indigent defense. We do obviously support Delegate Guzman's bill. It's very exciting to see this as the new trend to raise that age. That's obviously going with what's happening across the country. But Delegate Cole's bill really does have a broader understanding of the impact of that age across the entire juvenile system and not just relegated to those two certification code sections. Specifically, Delegate Cole's bill would go through, there's a provision in the code in 16.1-249 that allows a child to be housed in an adult jail pending trial or pending a disposition. That would not change with Delegate Guzman's bill, and we would still allow 14-year-olds to be housed in an adult jail under a certain amount of circumstances. What's particularly just upsetting about that bill is doesn't have to be based on a recommendation by a judge. It's actually based on a recommendation of a custodian. So not even a judicial representative has to make that determination, and a child can be held in an adult jail. And that is not addressed in Delegate Guzman's bill. Additionally, under 16.1-284.1, this is the code section that details when a juvenile can be committed and can go to a juvenile prison. Delegate Cole's bill would again raise that age to 16 instead of 14, and that would be to the Department of Juvenile Justice or to one of the post-dispositional programs, which allows a juvenile to be incarcerated for at least 6 months, and this would raise that age. The difference between a 14-year-old and a 16-year-old being placed in a situation would be you would have a 14-year-old who often in our system that might be a middle schooler who is going to be placed in the same programs as a child who can be 17 and 364 days. They can actually be held, an adult can be held in a juvenile facility so long as they have not been transferred into adults. The court can move them into an adult facility, but as long as their juvenile case is still going, even over 18-year-olds can be in those juvenile facilities. To expose our 14 and 15-year-old children to possibly adults, even in a juvenile facility, is not something that's addressed in Delegate Guzman's bill, but it is addressed in Delegate Cole's, and that's again under 284.1. In 285.1, this has to do with when a juvenile can again be committed to juvenile prison, and that's again with Delegate Cole's bill would raise that age to 16, and that's in line with all of the social sciences that really do show that even the difference between a 14 and 16-year-old in terms of their culpability, in terms of their impressionability, in terms of the impact of that kind of incarceration in a youth that young, it really does need to be expanded to 16 and not just limited to 14. An interesting part of Delegate Cole's bill that is not included in Delegate Guzman actually does have to do with adults who made mistakes as children. I right now have 2 young men who were charged as 14-year-olds, and they were convicted in juvenile court. They were adjudicated delinquent of felonies. I now have them both who they have possessed a firearm. Now, very often these children are not told all of the consequences of a juvenile felony. Almost all of my adult clients think that fell off their record and it doesn't affect them anymore. And yet, under our current code, those adjudications when they are 14 or 15 years old are now subjecting them to 5 years of mandatory minimum time as an adult. And that's for mistakes that they made 5 or 6 years ago when they were still children. And Delegate Cole's bill does address that in 18.2-308.2, which would, again, raise that age. It wouldn't get rid of it completely. It would just raise that age again from 14 to 16 so that the behavior that the child is going to be held accountable for the rest of their life would at least have to be triggered by a conviction at 16 years old. I would also just flag for this committee some inconsistency in the language generally on when we're talking about 14 versus 16. Some places in the code it says 14 or 16 or years or older at the time of the offense, And in other places in the code, it just says 14 or 16. And that is actually inconsistent even in the main code section that we're talking about, which is 269.1. A specifically says at the time of the offense, B and C does not. So I think that is something that the committee probably should address, because there is certainly a circumstance where there could be an intentional delay in prosecution for an offense that happened when the person was 14 or 16 until they turn 16 so that they can use the provisions under B and C, because it's not clear in the code. So I think that's something that's remiss actually in both sections.
Just a couple of questions. I'm sorry, I didn't want to cut you off. Did you have further statements that you want to make?
I was going to address 269.1 and that big difference, and then I should be happy to answer your questions. With regard to juvenile transfer and juvenile certification, those are two different procedures. One, as you've all heard, is mandatory based on the seriousness of the offense. And both bills would have that be raised to the age of 16, so that a circumstance where a judge does not have discretion is raised to 16. We all agree on that. The difference is in subsection A. And what's important about subsection A is it's not limited to violent felonies. It's not limited to serious offenses. What the section actually says is that they're charged with a charge that could be a felony, any felony. At the age of 14, they can be certified as an adult. So before the Munich Amendment, it would have been that you could have a 15-year-old charged with a murder who could not be transferred, but you would have a 14-year-old charged with grand larceny who could. And that's because under 14, any felony can be transferred to adult court. Delegate Guzman's amendment would not change that. The code says any felony can have that child at 14 transferred to adult court. Now the court then has to write a report. There's many factors they have to look at. They look at the seriousness of offense. They look at the child's background to determine if that would be appropriate. But they would be eligible even based on their first felony charge. It is not the serious offenses that are listed in B and C. And so Delegate Cole's bill looks at that, still would retain the discretion of the court for less serious offenses to see if it's appropriate to transfer the child, but again makes that age 16, because we are still talking about treating a child as an adult, and Delegate Cole changed all of the language to make sure we cannot have a 14 or 15-year-old charged as an adult in adult prison, adult court at 14 or 15 years old. So Delegate Cole's bill would change subsection A as well.
Thank you very much for all that guidance. So Delegate Cole's bill does a lot. It's covering what we've previously seen as 5 or 6 bills into sort of one larger omnibus bill. So if I could just ask a couple of questions just based on, there's an individual right now in Department of Juvenile Justice detention who I prosecuted, who executed another person in a graveyard over $50 of marijuana. He was at the time 14 and a half. By the time he was charged, he was 15. Would that individual be able to be put into the Department of Juvenile Justice under this bill? Committed, pardon me.
Would he be able to be committed under 284.1? I would say no.
So there's another individual who I prosecuted who raped another child who was under the age of 10. Would that individual be eligible for commitment with other juveniles under this bill?
How old did you say the charged child was?
14, and victim was under 10.
They would not be eligible for commitment, but they would still be eligible for the other dispositions under the code.
And for those who don't practice in juvenile court, what are the other dispositions that are eligible?
They could still go to juvenile detention.
Okay. And how long can one be held in juvenile detention?
Without post-dispositional, without any other type of commitment, it's 30 days.
So the worst penalty that I could receive if I, and Mr. Munich is making, okay. So the worst penalty that I could get for a 14 or 15-year-old rapist is 30 days in detention.
Well, in practice, they would be held much longer because that case is not going to go to disposition within 30 days. Typically, that case would take probably at least a year.
Yeah, and you're absolutely right, but in theory it's supposed to be 21 days
In
and then
theory.
30. So the way the code is written is that the maximum time that someone could be incarcerated for rape or murder is
the other, particularly if it's a sex offense, they would still have all of the other consequences of a sex offense, registry requirements and that sort of thing, loss of voting rights, loss of firearm rights, all of those outcomes of having this type of offense would still be on that child.
And I understand completely. I just want to make sure that we're talking about what I think we're talking about, which is a 14 or 15-year-old murderer or rapist could be incarcerated for only 51 days. And then that would be, I guess, post-D at that point, or Mr. Niemiec? It'd be post-D eligible learner?
Mr. Chairman, the change the Delegate Coles bill makes, it raises the age for post-D
Right.
from 14 to 16. So that's the disposition under 16-1284.1.
So we're not even having post-D eligibility.
Yeah, so they're not eligible for that.
So, for adults, the maximum penalty for murder is the possibility of execution.
Possibility.
In practice, we don't do that here in Virginia, at least any longer, I hope. But then if the person is 14 to 15, the maximum penalty is 51 days.
Yes, under the code. And certainly if that's the main hang-up of this committee, perhaps there could be a carve-out for post with dispositional or other consequences, but the main aspect of the bill that we're trying to get at is the full treatment of a juvenile as an adult. And as heinous as that might be, that person is still a child. And there is a litany of social science evidence that shows that that child can be rehabilitated, that that child doesn't understand the consequences of their actions at all. Another aspect of your scenario is typically when you have a child that young commit an offense of that nature, they're actually incompetent. And then you have to go through a full panoply of restoration proceedings to get them to the place that they could even have a trial. But under the code, you're right, it would be the 51 days. But practically speaking, it would take much longer than that to even get them to a place that they could have a trial.
Okay. No, I understand completely. But you still have someone who's dead.
You would.
Right.
But I think in pushing the age to 16, the purpose of not treating children as adults until the age of 16, and the reason this is happening across the country is because of the recognition of the child's brain at that age not understanding long-term consequences, not understanding the consequences of their actions, and also the effects of that type of incarceration on that child. Whereas if that child has intervention proceedings and has treatment and has rehabilitative services, they can go on and live a perfectly normal life without that type of reoffending. But placing them in prison and treating them as an adult with those very adult consequences has the effect of turning that child into a predator and having much more drastic consequences for that child than they would otherwise have in the juvenile system, keeping them in the juvenile system.
Just to be clear, someone who is raped or murdered or combination of it is not a predator?
I would say that while that would be predatory behavior, it's something that can be fixed with age, with treatment, with rehabilitation. Children are very open and susceptible to rehabilitation and to being changed because they are so young and malleable. Now, I would say if that's the concern, certainly 284.1 could be amended to address those concerns without addressing the rest of the statute, such as allowing a child to be in jail with adults, allowing any of the other parts with regard to serious commitment, prison sentence, that sort of thing. There could be a carve-out to allow for a more serious sentence.
And I certainly understand that's sort of the problem though with omnibus bills is that there are in this one, 7 major changes of which, there might be universal agreement on 3. There might be some agreement on 2, and there might be no agreement on 2 others. And so that's one of those things where you can go big or you can go small. And I think we saw someone going medium right before you. But Delegate Collins, you had a request to speak, and I'm sure there are others who would like to as well.
a murderer, I do criminal defense work, I also do juvenile work. If I knew this was in place and I had a rapist, I would not file any of those motions. I would go to my client and say, look, dude, we're going to try this thing in 21 days pursuant to the code, and you're going to get out 30 days later. What kind of treatment are we going to give these juveniles? Now, I do have clients who go into DJJ, and they have served a 1.5 years, 2 year sentences, where they have learned job skills and have gotten treatment. So I'm asking the question. You said we can treat our way out of this problem, but I'm wondering if you have a resolution, if you have a murderer that after 30 days they're released, and we don't have hands-on anymore. What treatment do you think is going to be available?
Well, as Mr. Enoch has mentioned, probation, they would still be under a probationary period. And unlike with adult sentences, wherein you can only impose the previously suspended sentence, with juveniles, it's 30 days every single time with any violation. So that juvenile could then be placed in probation with treatment services. If they don't comply, then every single time they don't comply, they can be held for at least 29 days prior, another 30 days at least, each and every time, if they're not complying. Now, if they're complying and they're doing everything they're supposed to be doing with treatment, then that would obviously be what the goal would be. But if they're not in compliance, then the juvenile court system, the system generally would still retain control over them. It would still offer that.
And I have one follow-up question. If a juvenile is convicted of a felony, doesn't that felony fall off their record at 29?
It does not.
But if they're convicted in juvenile court as a felon,
They are a felon for the rest of their lives.
when do we change that?
The 29 is from the firearm code. So
Okay.
you can possess a firearm after the age of 29 only if it's a non-violent. Or
If it's a
it's not even
non-violent
non-violent,
felony.
it's not one of the violent felonies listed in
Right.
182308.2. For criminal justice purposes, she's right. You're a felon for life. There's different rules about employment for juvenile convictions and other background checks. But I tell my juvenile clients that people like me, courts, police officers, judges, they're going to know you did this forever, unless it gets dismissed and expunged.
All right, thank you very much for those questions. If there are any other questions at this point from the committee, we would open this up to people who would like to speak in favor of this bill. Would there be anybody here who would like to speak against this bill? Please, come on.
Mr. Chairman, committee members, Derek Davis for Virginia Association of Commonwealth Attorneys. Our association would oppose this bill. If you think of the most heinous crime you can think of committed by a 15-year-old, it gives us no opportunity to transfer that to circuit court to come up with any meaningful sentence. And council here and Mr. Chairman asked questions, and y'all have addressed a lot of our concerns already, so I'm not going to repeat all that, keep you here any longer. But to address one of the concerns that the patron had made was that if we transfer them to circuit court, we can't provide service for them. That's not true. Just because we're transferring the case to circuit court, we still have at our disposal all the juvenile dispositions available. It doesn't mean just because they go there, they're automatically going to get a lengthy prison sentence. It just gives us more options to work with. So we would oppose it for that point. And again, if it remains in juvenile court, the juvenile court has no jurisdiction over that defendant once they reach 21. So you would lose the ability to do anything longer than that. And for those reasons we oppose, and again for the many other reasons that have already been brought up by the committee.
Thank you very much. Anybody else like to be able to speak on this bill? Hilliard Cole, you get the last word.
Again, Mr. Chair, I appreciate your time. Thank you all for hearing me out. I just want to leave some last few words when we talk about criminal justice reform again. When we're thinking about this, you kindly shared with me that it's at the age of 26 when our minds are fully formulated. I understand the concerns about rape, I understand the concerns about murder, but what we're looking at here is reforming our criminal justice system to say, hey, these are young people that still need to be given a second chance. They still can be reformed. We need to handle them, and I don't think this is being, getting soft on crime. This will be something different if we were addressing this for adults, but this is addressing young people, and we want to make sure that we are making sure that young people have the ability to continue and reform and show what they've been, learn from their actions and their mistakes, but we should still need to make sure that they're being treated like young people and not like adults at the age of 14 and 15. So I would hope that the bill would be reported to full committee. Thank you, Mr. Chair.
Thank you, Delegate Cole. Anybody else want to speak? Otherwise, we operate by motion. Going once, going twice. Appears that there are no motions at this time. Delegate Clark.
Thank you, Mr. Chair. I appreciate you all.
Delegate Lindsay. Chairman.
Chair, members of the committee,
Oh, sorry. Good to see you.
I can tell you that that was very interesting discussion. Wanted to get involved in it.
Are you volunteering for Crimson?
Not at all.
Oh. We would always love to have you.
That face was very expression.
I bet you there's some people who'd be more than happy to jump off if you're volunteering.
And I can tell you this piece of legislation won't be half as interesting. My bill deals with affording the opportunity for voir dire examination of persons who are prospective members of the jury pool. Long story short, Virginia is one of the few states that still allows for jury's determination of guilt and innocence, and then also jury sentencing. A lot of states, most, there are only 6 that permit jury, the situation of jury determination of guilt and innocence and then sentencing. Most leave that to a judge even after the jury has made the determination of guilt or innocence. And the growing tide is going in the direction of having jurors be well informed of what's going on and in terms of what the sentencing range would be for a particular person that is before them, and allow them the opportunity to weigh in as to whether or not they could sit and hear that sort of case, and if finding a person guilty, make the determination as to the sentence that the law prescribes.
And I apologize for a moment. I am going to step aside and turn this over to Delegate Watts. The pieces outside need to pay for it.
Frequently, the result of cases is that juries go through trials, then they hear the evidence, they find guilt or innocence, and then they're told this is the sentencing range. You have no choice. You have no alternative but to sentence within that range. A lot of times, jurors feel tricked. They feel that in instances where they compromise for a disposition, that there would have been an opportunity for the determination of what the imposition of the imposed sentence would be, and the reality is that indeed is not the case. This bill permits judges, prosecutors, or the defense to inform jurors during the jury selection about the range of punishment for the charges that the defendant faces. Allowing parties to tell the jury the truth about sentences ensure a fair and impartial jury process, both in terms of guilt and innocence and also on the sentencing phase. It also prevents mistrials at sentencing if jurors all of a sudden make a determination that they can't agree on a sentence because what they determined in the way of guilt or innocence made them uncomfortable when they found out what the range was. A lot of times that's with our mandatory minimum sentences. Other times is with the range of punishment because while a judge can go beneath certain sentencing, certain prescribed sentencing in terms of giving a suspended sentence or giving probation, jurors cannot. Now, a lot would say, or some may say, well, this is a bridge too far. But I'd say that it's already happening in some jurisdictions. Now, I'm told that Northern Virginia is incredibly progressive. I don't know, I only go through there every now and again. But one of the judges in Fairfax County, David Bernard, already has regularly been informing jurors of what the likely sentence, what the sentencing range would be should that person be found guilty of a given offense. And while this isn't scientific, it certainly, you know, is illustrative of the point that this is not something that's problematic in nature, and that in fact he has found that it is not in any way caused any compromise in terms of the final product. What I suspect would be said by those who are uninformed and uninitiated is that, well, if we give this information to the jurors, what's going to happen is we're going to have jury nullifications, and I say quite the contrary. Jury nullifications come in situations where persons are trying to come with an end result that's inconsistent with the evidence for reasons of their own. When you let people know in advance what they're signing up for, what the range of punishment is, for that nature of offense, that person can make an earnest determination within his or herself as to whether they can sit in judgment and make the appropriate termination. And impose the appropriate sentence. When you leave that information out and then you have them deal with guilt or innocence, that's more likely to bring about the jury nullification, because now they have gotten information that they didn't know, and it may make them uncomfortable in terms of the imposition of the sentence. And I think you all have been here long enough, and I'll leave it at that.
Thank you, Delegate Lindsay. Are there any questions of the committee for Delegate Lindsay?
Madam Chair.
Delegate Bell?
I don't know this, the jury trials, you know, what yours handled in our area, but not much how it's handled elsewhere. This has stuff beyond the specific issue you have is telling the jury ahead of time what the sentences will be and saying, can you proceed with the case? You know, but this also has things that we would think of as pretty common jury questions, interest in the cause. Going through jurors related to the party and interest in the cause. What we kind of go through is what I think of as a pretty standard voir dire. Do you know either party? You have family and law enforcement. Some of the questions people ask. Is this maybe for staff or Delegate Lindsay, if you know, are there other paragraphs that do this? Is this going to be I don't know how that part of the code fits together.
Madam Chairman,
There's other stuff that's not here. Not only is meant to be limiting, but is there someplace else that tells us all the other things we all have?
that language for the most part comes from 8.01358, which is the civil statute on voir dire examination. 192260 says that criminal cases should be conducted in the same manner. So that statute applies to that language, and when I say for the most part, because the only difference language that comes out from 8.01358 to bill is the right to ask such person, a juror directly any relevant questions to ascertain whether the juror can sit impartially in either the guilt or sentencing phase of the case. The rest of it comes directly from 8.01358, except for lines 18 to 20, starting at the court and ending with the case. That's obviously the crux of what Delegate Lindsay's trying to get to, those lines. The earlier lines, again, lifted directly out of 8.01358 minus the can sit impartially in either guilt or sentencing phase of the case.
And I'll add to that the other thing that we're shooting for here is that at least in this situation, in some jurisdictions are more progressive, some jurisdictions are less. And so what we want and what we strive for with this legislation is uniformity across the board, and we believe that this affords that opportunity.
Delegate Lindsay, so in your mind, how this would go would be you guys start with robbery and malicious wounding, probably, but either party would stand up before him and say, my client is charged with robbery and malicious wounding. Robbery is a 5 to life, malicious wounding is 5 to 20. You explain what that means, 5 years to 20 years.
judge, well, it depends on the jurisdiction, because in some situations, the judge is gonna just let them know what the sentencing range is, you know, because those judges get the voir dire questions, and then they make the determination to ask for themselves. In other jurisdictions, the judge, you know, wants to review the questions, but allows the lawyers to ask. But whichever approach a particular jurisdiction offers, long story short, what you're gonna have is the information being shared with the jurors on the front side as opposed to at the end of the trial.
Okay, Elliot, got it. It does, guys, staff, one more thing. Is sit impartially the language we use? So I understand what he said, which would be, judge describes it, and then there's some sort of vague language about, are y'all gonna be able to handle this case or something? Is sit impartially what we say, or do we mean, basically saying, can you hear the case?
Yeah.
In the city of Charlottesville, it's well thought that it's hard to get, it's very hard, if not impossible, to seat a marijuana jury. And just people say, I'm not willing to sit on this jury, I can't decide the case. Is impartially the?
Mr. Chairman, we don't use impartially in 8.01358. The language that they use is sensible of any bias or prejudice therein. But they don't use that language, that doesn't come.
Because impartially to me makes it just not for the plaintiff or defendant, not for the defendant or the Commonwealth, as opposed to.
And Mr. Chairman, I'll say that as to how we get to it, you know, that language is not something that I'm wedded to, whether it's impartially or whether it's does any member have a bias that prevents them from being able to follow the law. Either one of those is fine with me.
That is entirely the will of the committee, right? If we can have people eating off to the side or something like that, I did it right up here, but we want to keep.
I was following my leader's lead.
No, definitely not weird. Elliot Lindsay, so once I started looking at your bill, I was fascinated how much we are in the minority across the country in regards to this. Mr. Nemick, it's 6 other states that even allow judges to be sentencing?
There are 6 states that allow jury sentencing.
Okay. Do any of those 6 essentially tell the jury ahead of time, or are we really just one state left?
So, I don't have that information. The research I did, I wasn't able to tell whether or not that is. There's no laws in any of those states to the effect that says yes or no. So, practice, I don't know the answer to that question.
And just so I'm clear as well, this is already discretionary. A judge can log your on anything, honestly, if they wanted to.
A judge can, but the general practice in, at least in my years, and I practice, you know, from Hampton Roads to Richmond to, yeah, I do go to Northern Virginia every now and again, but it's a bridge too far. But again and again, what happens is there's limitations on what you can share, you know, or what you're allowed to get into in terms of the voir dire, and it really just depends on the judge.
Mr. Newton?
Mr. Chairman, it's actually not discretionary. The Supreme Court in Hill, or Commonwealth v. Hill, in 2002 held, and I'm quoting from the case, in a non-capital case, neither the defendant nor the Commonwealth has a constitutional or statutory right to question a jury panel about the range of punishment that may be imposed. So obviously the court has said that a statutory right can be given. But to say, you know, I know Judge Barnard in Fairfax actually wrote a very long opinion about it, so it's not a secret that he's doing this. But I would, you know, suggest that he's, you know, that's not discretionary at this point. That if somebody objects to the question, then the court has to, under this law, under Commonwealth v. Hill, say that the question can't be asked absent. And then obviously what Delegate Lindsay's trying to do is make new statutory language that allows that.
I guess I would echo what Delegate Lindsay is saying. I've certainly practiced primarily recently in Hampton Roads, but certainly in like to speak in, oh, I'm sorry, Delegate Scott.
No.
Oh, all right. Anybody like to be able to speak in favor of this bill? Ms. Shapiro.
Hello again, I promise I will be much less winded. Again, my name is Ashley Shapiro. I'm from Justice Forward and the sitting public defender. We at Justice Forward are very excited about this bill and very much support this bill. In practice, just to answer a few of the questions that Delegate Bell raised and that Delegate Mullen have raised, my understanding is that we are the only state of those 6 states who allow jury sentencing that don't tell them in the sentencing. And in terms of what actually happens in voir dire, that is our only time to ascertain any bias of the jurors. We don't get to then go to the sentencing phase and have another time where we can see if they can be fair and unbiased when it comes to the actual sentencing. It's important to note that for death penalty cases, you are allowed to voir dire on the sentencing, but that's actually to disqualify jurors that would not be willing to impose the death penalty. But we have not extended that to the rest of our litigation. So what we're saying is that we allow the jurors to not have any discretion when it comes to incarceration, but we only kick them off because they won't impose the death penalty, and that's the current state of the law. Additionally, with regard to it being discretionary, it is highly dependent on what jurisdiction and even what judge you have. Here in Richmond, our bench's policy is to not allow this line of questioning and to, in fact, possibly declare a mistrial for simply informing the jury of the law, to not give them any other facts, and all this bill is asking for is to allow them to be informed. It's not to opine as to the reasonableness of that sentence, it's just to simply allow that. And that's very important in a state like Virginia where we have so many statutes. Okay. That we have all these statutes that have these minimums that juries don't know. So I will stop speaking at the recommendation of our sponsor.
I would defer to
Yes.
Delegate Lindsay. He's done this before.
Yes, thank you.
Is there anyone else who would like to speak against this bill? Good evening.
Chairman, I'm David Ledbetter. I'm the Commonwealth's Attorney of the City of Waynesboro. I'm here on behalf of the Virginia Association of Commonwealth's Attorneys, and we respectfully stand in opposition to this bill. There's really 2 bases for the bill proposed. The first is informing the jury of the range of sentencing. It would invite jury nullification. There's many things that we don't tell juries that we think would affect their ability to sit impartially. Just like we don't tell them about range of sentencing, we don't tell them about in the guilt phase or ahead of time what the defendant's prior record is, or the fact that he's committed the same exact act that he's charged with here before. We do inform them in voir dire what the nature of the charge is against him, and that they're also informed that if they sit and find the person guilty, they are going to have to come back and sit in sentencing. I know it is certainly my habit. I have members of certain religious communities in my area that it's against their religion to sit in judgment of others. So I have to ask that question: do you have a moral, ethical, or religious objection to sitting in a judgment of another person? And that fleshes out people that probably should not have the ability, do not possess the ability to sit impartially on a jury or to render a verdict. The second part of the bill that we object to is the language that says can ask any relevant question, and then it goes on to incorporate much of the language of 801-358. That any relevant question is not in 801-358. We would submit many questions that are relevant, could be asked, but should not be asked. It is clear now under the existing law that the judge can limit down voir dire, because you could imagine if the standard's any relevant question, I can think of a lot of relevant questions that could go on for hours and hours, but really aren't material as to their ability to sit impartially. So we have some problem with that part of the language. But overall, we
I'm sorry, which line are you talking about for that second issue? I certainly understand your first.
the line 15, to juror directly any relevant question to ascertain. I do not believe any relevant question is in 801-358. I think it's limited just ask questions as to are they related, has an interest, has expressed or formed an opinion, or sensible of any bias, prejudice therein.
Mr. Mubick is shaking his head.
I got that wrong, Mr. Mubick?
8.01-358 says the court and counsel for either party shall have the right to examine under oath any person who is called as a juror therein, and shall have the right to ask such person or jury directly any relevant question to ascertain whether he is related to. What the case law says is it has to be relevant to the factors listed in 8.01-358.
Well, I'll withdraw that. And also, I think it's important to point out that the decision not immediately beyond the conclusion of the jury's sentencing recommendation. He gets a pre-sentence investigation report. There's a whole other sentencing hearing, so a judge can depart. Now, I'm not able to tell the committee how much departure is, but the final arbiter is the judge who is aware of many more facts than what the jury is.
Thank you. I think Delegate L has a question too. So, this is most of what we do up here we've seen in various ways before. We kind of have thought it through. This is something new.
Yes.
And feels like everybody is talking around some things that everybody practices knows. And so I'm going to just ask you some things. So there would certainly be a benefit in some defense cases from a defense perspective if the jury knew the ranges, because the thought would be that when they go in the back room and Delegate Lindsay was nice enough to put it out there, when they're doing a compromise verdict, they can kind of squish things together and come up with, we think he should get 7 years. And if they know that one's a 5-year, one's a 1 to 5, and one's a 20-year, they can use that as part of their interpretation. Okay. But that's not what this bill does. This bill said everybody gets to ask at the beginning, isn't there sort of some trade-offs, or everybody gets something that would make the system run better if at the front end you can say it's 5 to 20, 5 to 20, and somebody says, oh, there's no way I'm going to give him 10 years. And then the prosecutor, the defense gets that the information is now in the jury's head. They kind of know the range. But the prosecutor at the front end can say, okay, that's fine. Just like if you're a death eligible case and you say, I can't do death, or the Mennonites say they can't do judgment in person. Okay, that person is somebody, he just says, I'm never in my life going to give somebody 20 years. You say, okay, that judge, Your Honor, that's what the charges are. Aren't those some trade-offs that would balance this out some?
It is a trade-off in that we would know if somebody could sit within that range of punishment, but I would submit to you it would change much of the focus on the deliberations as to that range of punishment. I think it would also hurt the Commonwealth, because I had a jury recently where we ended up not being able to sit an unbiased juror because the juror had done research and found out it was a mandatory life sentence. And before we could get the jury into the courtroom to begin voir dire, because we do not have a separate room, she was talking it up in front of other jurors, the fact that they have no choice but life. And that really created a great deal of consternation amongst the jurors, and we were unable to get to that. I think range of punishment should be best be told outside of the guilt phase.
Thank you. Delegate Carol Floyd.
Excuse me. Mr. Chairman, I think it's, I thank the Painter for bringing this bill. In the juries that I've seen, I've had jurors say, I wish I would have known. I wish I would have known how much time this person could have been given, or whatever may have you. And I think it's pretty paternalistic of us to say we need to protect the jurors, the people who are making decisions about people's freedoms and lives and futures. We need to protect them from information because we might not like the result of them having all of the information. So that is what this is really about. It's about giving them all the information to make an informed decision about who they're standing in judgment and what they're standing in judgment for. So I don't think that we should be so paternalistic and coddle jurors and say, we want to protect you from information that we may think is uncomfortable to you, right? So if we think that some jurors may have a problem with the mandatory minimums that we have in Virginia or the sentencing range, then that's the problem. Not that we need to protect and not disclose that information to the jurors. So I think this is a timely bill. I think it should have been brought a long time ago. I think that jurors need more information, not less. It's a very important job that we're asking them to do, and we need to fully arm them with the information they need to make these decisions. Thank you.
Mr. Chairman, as a respectful response to that, if we're going to fully inform the jurors, I would ask the question, are we going to tell them about their prior record? Because that could be relevant also. Are we going to tell them they committed other similar acts in other jurisdictions in the same time frame? Again, that's full disclosure of information. We don't disclose that because we feel it's not prejudicial to the jurors or trying to protect the jurors. It's prejudicial to the defendant and weighs in on his ability to get a fair and impartial trial.
And I totally agree. Aren't there also constitutional reasons why we don't inform them?
We do. And so what we wish to do by withholding the information is to ensure that the defendant obtains a fair trial, but also that the Commonwealth has the ability, and we carry a much higher burden. We carry proof beyond a reasonable doubt. We carry all the burden of proof. They don't have to produce any evidence. I mean, it's the Commonwealth's burden. We need to make
so that's the issue.
And I appreciate that because just feeling the temperature of the dais, I think we're gonna be moving forward on something like this, and so I wanna make sure that.
There's been a suggestion by council that I don't have heartburn with, that may very well be a compromise that suits the interests of all that have spoken on the dais.
Mr. Meaden?
Mr. Chairman, I think to get what Delegate Lindsay is trying to get to, and also what Delegate Bell's issues are, is if we just change the language of the bill to in any criminal case, and then start with line 18 where it starts with the court, and end at on line 20 after sentencing phase of the case, and just use that sentence. If we don't repeat language that's put in another code section, we don't add new language to this code section other than what the patron wants, and it is very clear that the court is allowed to then, or the court or counsel is allowed to inform the person and ask them questions about it, of the punishing range, their punishment range.
So, just.
May I inquire of
Yes,
counsel?
of course.
And in that regard, it leaves it within the court to make the determination in managing the court as to what's reasonable and material. Would that not be correct?
It would be the court's discretion as to whether a question, a further question asked other than that, is about sentencing is relevant to the case.
So it doesn't open it up to questions about what the favorite candy bar is, but
Yeah.
it does focus on the meat of what you're talking about.
And that's my intended goal, and I take no offense if that's an amendment that's offered by one of the committee members.
So moved.
And is there a second?
Second.
All right, there is a motion and a second to this friendly amendment. All those in favor, please say aye.
Aye.
Nays? Doesn't sound like it. So, we've had some, I think, some pretty robust discussion. Is there anybody else who'd like to speak on this before we have any motions? Last words?
Have a motion? Move report?
There's a motion, there's a motion and a second to report this bill as amended.
Chair, just speaking, sorry, it's okay, just speaking, I reserve the right to think more. I'm gonna vote no, but I'm still thinking about it, it's gonna be an even for you. Okay, thank you.
All those in favor, please vote. Electronic voting machine or ordinance, whatever you want.
Thank you, Mr. Chairman, members of the committee.
Delegate Lindsay, that is the most substantial change that we've done to the jury system in about 2 decades.
That is true. Mr. Chairman, I have a motion.
To adjourn? What?
No?
We're not getting away that easy. Delegate Watson, please.
Having voted on the prevailing side, when we re-referred a block of votes, I'd like to reconsider that vote for the purpose of sending two of the bills to a different subcommittee, a different committee.
And I would second that motion. Can you explain the motion a little bit so everybody knows what
The two
we're
that,
recommending?
upon looking at HB 1119 and HB 1185, there are references to the code sections in 58.1 on excise taxes. Those code sections in that chapter have a significant number of very heavy civil penalties, but also a number of Class 1 misdemeanors, several Class 6 felonies, several Class 5 felonies, and therefore I think the enforcement of these products is what is going to be most challenging, not HWI consideration of those products.
So just to be clear, we have 2 bills that we were about to refer to HWI that should probably be
amendment, okay, to the bill. This is House Bill 444.
Mr. Chair, I can report the amendments.
Please.
It would be on line 14. You would insert travel lane.
Okay.
And then on line 14, after clippings, insert so as to create a hazard to the traveling public.
Alright, so I got one, but I didn't get the second. Can you repeat those one last time, just for those who are slow?
Yes, and the second one was on line 14, after clippings, insert so as to create a hazard to the traveling public. The first one was also on line 14 to insert travel lane, and I'm
Perfect, I appreciate it. Please.
Thank you.
Good to see you again.
Nice to see you too. So this bill was brought forward, and biggest concern, of course, is with our motorcycle riders. And it's pretty self-explanatory because grass can be a hazard on the highways. In Illinois this year, in June, a woman actually died because she lost control of her motorcycle on grassy lane. Even in Illinois, they actually have grass as a hazard in their, what's it called, the littering statute in Illinois. And so this is just kind of precautionary measure. We want people to be aware, and we want to make sure that if you intentionally throw your grass on the highway, that there could be consequences if someone has an accident.
I appreciate